I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introduction to open meeting law, our latest round of video tutorials and other lessons on freedom of information laws in New England. If you haven't already, please check out our previous lessons on public record laws and the Federal Freedom of Information Act. All lessons are available to view at nefac.org/FOI guide. In addition to more video tutorials, you'll also find there other helpful resources such as common Q&As, notable case law, and an FOI legislation tracker. This round of lessons is brought to you by NEFAC with help from the Society of Professional Journalists Foundation, the Rhode Island Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. We're grateful for everyone's support. Thank you. Now, here's NEFAC's Emily Sweeney to introduce you to your instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on freedom of information laws. This session is going to focus on the open meeting law in Maine. And with us is Sig Schutz. He's a partner at Preddy Flaherty in Portland, and he's been newsroom counsel to Maine's largest news organization, that's Maine Today Media, for more than 20 years. Thank you so much, Sig, for doing this and giving us an overview of the open meeting law.
Thank you, Emily. Good afternoon. It's nice to see you again. Pleasure to be with you. So everything you wanted to know about Maine's open meetings law in 30 minutes. I'll start with the purpose of the law. And the law is meant to give the public access to information about what government's up to. And so that generally means that government meetings are open to the public, and government records also are open to the public on request. So the focus here, of course, is meetings, not records, but there are records associated with meetings, and it's important to get those records, and increasingly they would include things like the meeting audio, the meeting video, notes taken by the participants in the meeting, the agenda, any decisions made at the meeting, meeting handouts or packets, and even email sent during or related to the meeting. The essential idea of these laws, Maine's open meeting law, other states have similar laws, I think every state has a similar law, is that government accountability goes hand in hand with an educated and informed citizenry. So we need to know what government's up to, and to know what government's up to, we need to be able to attend meetings where our elected representatives or appointed representatives are conducting government business. And that's that purpose is set out in Maine statute. It's actually in Title I, Section 401. There's a section that refers to the legislature, the legislative findings that the public's business is aided by open deliberations, and that it's the intent of the legislature that clandestine meetings, conferences, or meetings held on private property without proper notice and ample opportunity for attendance not be used to defeat the public's right to know. So I'll just then comment a little bit on legal framework. The name of the Maine statute is the Freedom of Access Act, and that's found in Title I, Sections 400 to 414. If you throw that into Google, Maine statute, Title I, Section 400, that'll bring you right to this act. It's sometimes called the Right to Know Law or the Sunshine Law. The federal equivalent is the Government in Sunshine Act. Federal law does not apply to Maine agencies or bodies. Federal law applies to federal agencies. Maine law applies to Maine agencies and bodies in this instance. So we look to Maine statute, and if you don't like what Maine statute has to say, the legislature can change it. I always say to people who ask me for guidance on public records or public meetings laws who don't like the answer, that they're kind of shooting the messenger in this instance. The legislature has decided what the rules of the road are on access. Sometimes with good reason, sometimes arguably without. The general idea, and this is in Section 403 of the Act, is that all public proceedings are open to the public. And that means that by state law, the public has a right to attend public meetings. That does not mean the right to speak, that only means the right to attend. Now, there may be other legal requirements that give members of the public the right to speak. For example, a public hearing on an application for a license or permit, Public hearings obviously are intended to solicit public comment, but that's something outside the Freedom of Access Act. There is no residency or citizenship requirement for attendance. Anyone can attend, any member of the public. And then records of public meetings are required, at least rough minutes of public meetings are required by Maine law. So that's got to include the date, time of the meeting, the presence or absence of any member, and motions and votes taken at the meeting. There are, again, more specific requirements on record creation for certain types of public meetings, adjudicatory proceedings, proceedings involving an application for a license or permit. There are more detailed record creation requirements there, but for general public meetings, at least minutes are required. Can you broadcast or record public meetings? In Maine, the answer is yes. There's a statutory right to do so. There is also a provision allowing agencies to impose reasonable regulations on the right to broadcast and record. So if you do intend to record or broadcast, it would be best to check with the clerk of the agency or the appropriate official in advance to make sure you have guidance about what their expectations are up front. And so that you can also, if it's going to be an elaborate recording, then you have time to set up your cameras and your microphones and all the rest. If it's going to be putting your iPhone next to the speaker, you just want to check that no one's surprised. And frankly, you want to check that they don't have some kind of last minute objection where you might need to educate them about your right to record or broadcast the proceeding. Fundamentally, what is a public proceeding under Maine law? Under Maine law, a public proceeding is defined as the transaction of any function, of any governmental function by a long list of governmental entities. So in general, all state agencies, state and local boards and commissions, those are all required to have public meetings. And just about all multi-member meetings of government bodies must be held in public. So that would include anything from the Board of Environmental Protection to meetings of the county commissioners, town council, zoning or planning boards, and school boards. Meetings of agency staff are not public meetings. You don't have a right to attend a meeting between the code enforcement officer and the town manager. But you have a right to attend, of course, a meeting of the zoning board or the town council. There are, except for a few specific exempted activities, virtually every activity or action of a body, of a public body in Maine is subject to the right to know law. And so that would include even things like a zoning or planning board site walk. Public has a right to notice and an opportunity to attend. Public bodies can also sometimes include quasi-governmental agencies like hospital administrative districts established by the legislature. The courts have established a 4-part functional equivalency test to assess whether a quasi-governmental body is subject to the right to know law. And so in some instances, those bodies can be subject to their records can be public and their meetings have to be noticed and held in public as well. What about notice? What kind of notice is required? Notice, of course, is required of all public proceedings. The statute doesn't set any deadlines and is not overly prescriptive in terms of the specifics of notice. Notice has to be given in ample time to allow public attendance. Again, ample time is not defined by state law. Many bodies will have specific deadlines for specific types of meetings in ordinance or procedure or potentially in other statutes. Best practice is that notice include an agenda for a public body so that the public knows what matters are being discussed, but state statute doesn't actually specifically require an agenda. I think at minimum, a body's got to give notice of the date, time, and location of a meeting, and at least generally the topics of anticipated discussion. There is no Maine authority specifically addressing the precise line between what's adequate notice and information that's so sketchy that it falls short of sufficient notice to the public. Notice is also required regardless of the number of people who actually show up. So if you've got a 3-person body and only 2 people show up, that body still has to have provided public notice. There's also no reference in Maine law to the question of whether notice is only required or public access is only required where there's a quorum. My position has always been that quorum really doesn't matter. That's not mentioned by statute. As long as a meeting goes forward, it's got to be open to the public. If a decision is made that a meeting can't go forward, can't take place because a quorum is not present, then there's no meeting, nothing happens. But if members decide to show up and have any form of discussion, even without a quorum, the public still has a right to attend. Emergencies do happen. The statute provides for emergencies. During the early phase of COVID, there were a number of emergency meetings, of course. Emergency meetings notice is still required, and that's actually the only area of the Freedom of Access Act, I believe, that gives the news media special rights over the general public. The general public has the same rights as journalists to access to meetings, except for emergency meetings. Where there's an emergency meeting, members of the media actually have to be notified by the same means or faster means than those used to notify the members of the body itself as to attend the meeting. So executive sessions. What is an executive session? That's the term of art in the Maine statute. It's a secret meeting. It's a closed to the public meeting. And Maine does allow executive sessions, like is true everywhere, on certain limited topics, and only subject to certain procedural safeguards on the meeting, on the circumstances under which a discussion could be held in private. So as for procedure, while the Act is generally silent about the procedure for public meetings, a lot of bodies will follow Robert's Rules of Order. But when it comes to executive sessions, the law is pretty specific. If a public body wants to go into executive session, a motion needs to be made stating the precise nature of the business. Then there's got to be a 3/5 vote of those attending. And the motion must also cite to a provision of state statute authorizing that discussion in executive session. No other subjects may be discussed in executive session. That is, no subjects outside the scope of the motion. And under no circumstances can any official action be taken in executive session. What that means is no votes, no straw polls, no votes in executive session. The body can go in, have the discussion, then needs to come out and take a public recorded vote on whatever the matter is, if a vote's required. And of course, and if a court determines that a body or agency has acted illegally in executive session, taken official action in executive session, that action can be declared null and void. So what kinds of matters can a public agency discuss in secret? That is in executive session. Those matters are generally set out by statute, and there are a few common ones. A frequently used reason for executive session is personnel matters. Under Maine law, personnel matters can be discussed in executive session, but only where the person's reputation or right to privacy would be violated. And even there, the individual under discussion is allowed to attend and may request that the meeting be open. And if requested, the meeting must then be open. Public agencies can discuss real estate or economic development matters in executive session where premature disclosure would hurt the competitive or bargaining position of the agency. Labor contracts and proposals can be discussed in executive session. And then agencies can also consult with their lawyers about pending litigation or otherwise where premature disclosure would clearly, and this is the words of the statute, clearly place the body or agency at substantial disadvantage. So not all consultation with counsel should take place in executive session, but where consultation with counsel in public would disclose information to an adversary in litigation or otherwise put the agency at disadvantage, that can take place in secret. Then there are some other topics as well that can be discussed in executive session as provided by state statute, and that's Title 1, Section 405 lists the statutory, contains the list of matters that can be discussed in secret. If minutes are taken during an executive session, those minutes are confidential. Minutes or notes taken during executive session, that is confidential. Some agencies will do that. Some agencies will not, for fear that there may be leaks. What about another topic? Email and text messages. Actually, in Maine, meetings by email or text message or Facebook are illegal. The Maine Attorney General has put out specific guidance that email should not be used to circumvent the right to know law. email is permissible to schedule something or for routine matters, but members of a body should refrain from use of email as a substitute for deliberating or deciding substantive matters properly confined to public proceedings. And something else that's come up recently is especially post or during COVID are remote meetings. Can remote meetings be held? Old guidance in Maine was no. Remote meetings were not permissible. That guidance goes back many years. As a result of COVID, first there was emergency authorization, and now there's permanent authorization for remote meetings, but they're subject to a pretty tight and strict set of standards. They're possible, but only where in-person participation by a member is not practicable, and where the body complies with other requirements of the law, including allowing for remote attendance by members of the public. So members of the public still have to be provided with meaningful opportunity to attend by remote means when members of the body itself, the government agency, are participating remotely. And then, of course, all documents and other materials must be made available to members of the public participating remotely to the same extent customarily available to the public attending in person. Bodies wishing to engage in remote meetings or authorize meetings by Zoom also have to adopt a policy, a written policy on remote participation after notice and public hearing. And the public hearing to adopt the policy has to be in person. So no remote meeting to figure out what your policy is going to be on remote meetings. I'll cover two more things: remedies and practical advice that I can offer. Remedies. There is no in Maine administrative agency or bureau overseeing or enforcing the Public Access Act generally. There is an ombudsman in the Attorney General's office who is authorized to accept complaints. She does not have enforcement authority, but she can mediate and assist in answering questions or resolving issues. To appeal from or to challenge in court is really your only option. And that means filing a civil action in state superior court, typically where the meeting took place, within 30 days of the date the meeting was held, or within 30 days or as soon as possible after an illegal meeting is discovered to have taken place. It's important to act promptly on discovery of a meeting, not to wait. The court will look for the plaintiff to show that there was an illegal executive session or violation of the act. And then once it's shown that there was an executive session, the burden is on the agency to show that nothing illegal was discussed during that executive session. Under Maine law, there are no fines. There is no monetary penalty. There can be recovery of attorney's fees, but only if there's a showing that the agency acted in bad faith. And as I mentioned earlier, the court can nullify any final action taken in an illegal secret meeting and require disclosure of notes or records related to the meeting. So a few practical comments or some advice. If you're faced with potential access issues related to a meeting, ask, where does it say that? Show me where it says that. Where in state statute are you allowed to do that? And by the same token, point out, well, there's state statute here that says I'm allowed to attend. What gives? So show me where it says that. I always say, don't take no for an answer. You can certainly raise your hand. You can say something, but don't get arrested either. It's not going to help, and it's not going to convince the agency, at least then and there, to do more. If you expect a problem, it's always nice to know what the law is going in. If it's a somewhat unusual type of meeting, a meeting where there may be some question about whether it has to take place in public, or where there's some discussion that may be on the edge of something that might be permissible for executive session, check the law up front. I would also suggest elevating the issue. If you're getting pushback from a clerk or someone at the agency who doesn't seem to be understanding or cooperative, politely, but you can ask for the supervisor, go to the chairperson, go to the commissioner of the agency, go to the town manager, go to the lawyer representing the public body. Who's the town's lawyer on this? Who at the Attorney General's office is assisting the agency on this interpretation? I don't agree with it, and have that discussion. You can involve the ombudsman. You can also involve your own lawyer. And as sometimes the person that gets that call, I would just say, don't call your lawyer an hour before the meeting and expect to get an injunction from a court. It's just not going to happen. So get ahead of the issue. If you expect a problem, get out in front of it as far out in advance as you can. And obviously the best remedy to prevent a closed meeting that should have been public is to deal with it up front, because you're never going to really be able to recreate after the fact what took place, even if you're successful in a challenge down the road.
Sig, thank you so much.
You're very welcome. Thank you.